What's true? True is the selection, service, and extrusion.
All right, good morning, welcome back. You may be seated. Okay, ready to proceed? I think we have rebuttal closing, is that right?
Yes, Your Honor. I filed those jury instructions you asked us to file last night.
Okay. Just for the record?
No, just for the record.
Okay. All right, let's bring out the jury.
And you sent the verdict form also, that you also denied.
All right.
Jury entering.
All right, counsel may be seated. Welcome back, ladies and gentlemen. This time we are going to have the rebuttal closing by the state, and then I have some final instructions for you. Ms. Laura, the floor is yours.
May it please the court, counsel. Good morning, ladies and gentlemen. Deflect, deflect, deflect. That's what this case, from the defense perspective.
Objection, Judge. We approve.
Yes.
Deflect, deflect, deflect. They don't want you to look at her words, her actions. Ask yourself why. Why? Because they proved solicitation to commit first-degree murder.
Objection, Judge. We approve.
Yes.
Her words on those tapes, her words on those videos prove the crime charged. It's easy to point the finger at someone else and deflect attention away. They're blaming the police. Well, let's look at what we know. She went to Mohammed Shihada for help. She rekindles a relationship with him while married in order to get help. She tells him she's abused. According to what Mohammed testified to, and according to what's on that video at the mobile gas station, she gets some guys in Riviera to help her commit this hit. That doesn't work out. She then, Mohammed says, gets her gun, his gun. At that point, he realizes she's so serious that he feels the need to go to the police. Now, he even admitted to you on the stand, he thinks she's serious. And he said to Mr. Williams, you know, at first I didn't think that she had it in her. And then he said, well, based on everything, he goes, yeah, I guess she did. Even he saw she meant to do this. Now, Mohammed told you that the defendant claimed that there was domestic violence. There is absolutely no evidence of this. And in fact, Mr. Shihada was questioned about a statement that he had previously made of what the defendant told him. about this violence, and that she later said something different. And he said that she said that her husband is a very nice, nerdy guy, that she can pretty much do whatever she needs to do with him. Like if she asks him to do something, he'll do it. That the real reason he's not really abusive, that there's some kind of had to do with money and probation. She spent it and needed to replace it. She doesn't want to live with him. She doesn't like him, and she wants him to go to jail. She's not abused. Look at her in those videos. Does that look like an abused woman to you? No. Now, they want you to believe that the Boynton Beach Police Department did everything wrong in this case, from top to bottom, everything wrong, and that they forced Muhammad into everything. That is the farthest thing from the truth. Muhammad told you that he actually was telling a friend, quote, "I'm not going to be able to sleep knowing that someone would get killed. I have to get it off my chest." Now, is he gung-ho to run out and do this? No. Think about it. Do you think that someone wants to turn their lover in for trying to kill their husband? Do you think someone would be excited to do that? No. But he knew he had to do it because he knew she was serious. He wasn't threatened like I want you to believe. He was asked on the stand if he was scared. And he said that he wouldn't use the word scared, but it wasn't something he wanted to go through.
Objection. Facts not in evidence shows from the statement of the testimony.
Overruled.
I'm just going to tell you now. What I say isn't evidence. What they said isn't evidence. You rely on your own recollection of evidence, okay? Sergeant Ramsey, Detective Moreno both testified to you that Muhammad was never threatened. Did they laugh at him? Yeah. Wouldn't you maybe get a chuckle when someone comes in of an allegation that their lover wants to put a hit out on her husband, yet he doesn't even know her last name? Kind of seems odd. Might make someone think this is weird and chuckle. Doesn't mean they're laughing, thinking, ha 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 ha, let's make some big spectacle out of this. And they didn't force him to be a confidential informant. Muhammad Shihada sat on that stand and said that the police allowed him to go out and call his lawyer. He called Ian Goldstein, a 25-year seasoned criminal defense attorney. And he consulted Mr. Goldstein about this confidential informant packet. And after consulting with him, he signed it. So don't be fooled into thinking that he was rushed in 2 minutes to signing that packet.
Objection. Facts not in evidence. We approach.
You may approach.
Consulted him, and after doing so, signed that packet. There wasn't a threat of, this threat of prosecution. Yeah, he was warned, if you're complicit and don't assist, you could be guilty in helping this go through. And they want you to think that Muhammad was tricked into wiring his car. That's inconsistent with the testimony you heard. You heard that that car was wired on August 1st before he went to the mobile gas station, not on the 31st when he came in. And in fact, even Muhammad told you they didn't even want him to do anything until the next day. Now, they've made a big deal of the first interview with Muhammad not being tape. He went into the department. They took his statement. Detective Brown took his statement. After talking to him, they put him on tape and they took his statement again. Now, according to their expert, that's 100% wrong, never should be done. But according to Sergeant Ramsey, who they called as a witness, that's a regular practice for Sergeant Ramsey because he wants to establish rapport with someone. And they want you to, they said yesterday in their closing that the allegation, or they stated that this whole thing was scripted. Before they even got a statement, they thought, oh, great, cops is coming, we got this script, we'll do this whole thing. Think for yourself for a second. If they hadn't even taken his statement yet, how could they have come up with a script? They didn't even know what he was going to say. It doesn't make sense. He came in, he told him the information he had. They then put him on tape, took it again. He signed a CI packet. Now these controlled calls, go and look at Muhammad's records. His cell phone records are in evidence. There aren't 20 to 30 controlled calls that they want you to believe that aren't taped. Look at those records. A great deal of those calls are 0 in duration, 0 seconds. Even a lot of them are 2 seconds, 4 seconds. Do you think 2 seconds is enough time? 4 seconds, 10 seconds is enough time to threaten someone into doing this? That doesn't make any sense. Now, Muhammad said that he was called at 2, 3, and 4 a.m. by Detective Moreno. Look at those records. That's not in there. You're not permitted to speculate. You're not permitted to go back in that jury room and say, well, maybe there was these calls. Look at those records. Look at the evidence. In opening, think back to opening for a second. They told you there was
Objection.
5...
Can we approach?
Yes?
In their opening, you heard that there were 576 phone calls. That is absolutely untrue. Look at those records. Sergeant Ramsey, let's talk about him for a second. Sergeant Ramsey was brought in, questioned on policy violations, that he would have done this differently. He wanted to go get a wire that worked. Well, according to Sergeant Bonfair, Sergeant Ramsey had access to a digital recorder. Did he get that? No. Sergeant Ramsey's pretty quick to Monday morning quarterback. But Sergeant Ramsey told you one really, really important thing. Those policies that they questioned Sergeant Ramsey about, he said those are guidelines, not the law. Ramsey told you one really important thing other than that. Chili's, her body language. He said he watched her. He was sitting in that parking lot conducting surveillance on the defendant when she went in to meet with Muhammad. And he was questioned, what was her demeanor like? He's been a detective for a really long time, but a sergeant, police officer. He said she didn't seem terrified going in. She didn't seem terrified coming out. Very casual, actually, is how he described her. And look at the video with Woody John right after the fact, because she leaves Chili's, goes to CVS, 500 feet away and meets Woody. Does that look like a terrified woman to you? No. She gets in that car, she giggles, she flirts with him. She's not terrified. She's doing exactly what she intends to do, have her husband murdered. Now, their expert, Mr. Williams. Their $325 per hour expert, who's never done a solicitation to commit murder case investigation. He's only ever handled 3 to 5 confidential informants in his extensive career. But they want you to think, as I believe they said in their closing, that he's the best officer in the nation. His testimony conflicts with the testimony they want you to rely on from Officer Ramsey. And he says no investigation should ever be reported. I guess maybe he's never seen the show The First 48.
Objection. That's not an evidence, Judge.
Overruled.
Now, you should discount him for several really important reasons. He admitted on the stand He never watched the video between the defendant and Mohammed Shihad at that mobile gas station. He never watched the video between the defendant and Whitty John. He never reviewed the phone records.
Objection, facts not in evidence, Judge.
Overruled, Mr. Rosenfeld.
I'm sure he never even knew of the defendant's statement that her husband wasn't abusive. He was just a nerdy guy.
Objection, vouching for the witness, Judge.
Overruled.
Please remember, the jury instructions talk about experts. They talk about weighing the credibility of witnesses, and that's probably one of the most important jobs you have as a juror, to weigh the evidence and look at the credibility of witnesses. And there's instructions specifically about experts that says their testimony is to be treated like any other witness. Just because they come in as a titled expert doesn't mean you have to believe them. You can believe any or all or none of their testimony. That's your decision. Now these YouTube postings. What does YouTube have to do with this case? Nothing, I submit to you, nothing other than a distraction. Stephanie Slater testified to you that that staged crime scene video that you saw was what was put on YouTube. And she says yes, as the public information officer, she posts things to YouTube. Her job is to promote the Boynton Beach Police Department to the community. They post things to help solve crimes and to establish a rapport with the community. She posted a video of a crime that was complete on August 3rd. Why is that video important though? That video shows you her reaction. She left that house at 6 a.m. that morning, just like she had planned with Whitty Jean. And she comes back to that scene. And she's told, ma'am, I hate to tell you, your husband's been killed. And she starts crying. But there wasn't a single tear. Because a woman who didn't want her husband dead, do you think she wouldn't be crying? No. It's an act. She's probably dancing inside. She thought she got what she wanted. Now let's go back to the Chili's for a second. A very big part of their closing was this audio at the Chili's and that it wasn't recorded. Well, let's talk about who thought it was recorded. The only person who said he thought it was recorded was Mohammed, a person who I submit to you is uncredible. All the law enforcement officers, Ramsey, Moreno, everyone said it wasn't recorded. They want you to believe that Mohammed thought that it was wired, said that it was wired, but also believe Ramsey that it wasn't working and that he was going to go somewhere to get a wire, but that Sheridan told him not to. That all conflicts. They want you to think that she was threatened. That's what they're trying to plant in your head. She was threatened into doing this. Again, look at her. Does she look threatened? No. Now, the time frame. They want you to think, oh, Boynton Beach, we're going to get on cops, we got to do this in 72 hours. Think for a second. You should probably say to yourself, why by Wednesday? What is the 72 hours? She said the 72 hours. Go back and watch those videos. She kept saying, I want this done immediately. She met with Whitty. I want this, can we get this done by Wednesday? And she's saying to Mohammed, well, if he's not going to do it, I'll just get my gun back. Didn't I pay for it? She set that time period. Now, they also are very critical of not notifying Mike Dippolito. Why would you notify him so that when she comes home, one can probably think human reaction is that he's going to confront her. You're trying to have me murdered? And the whole thing's going to fall apart. The police are trying to conduct an investigation of a woman who's trying to hire a hitman to kill her husband. They have it under control because the way this is all going down, they're conducting the hit, not her. There's no need to notify Mike Dippolito. It'll sack an entire investigation. She'd get away with it, and who knows, maybe they'll try to do it again. Now, there was an...
Objection, Judge, will you approach?
Yes.
Now, they argued to you a lack of intent on behalf of the defendant. Because one of the things is they say that Whitty saying, her telling Whitty, you caught me off guard. Well, go back and watch it. She's talking about money when he's asking about money. Because one interesting thing throughout all this, she's very stingy with that money. She keeps saying, I can't just go out and give more. And in fact, think about a very disturbing thing. She tries to get Whitty, well, can't we do this at the bank? That's part of the whole key issue. And they said, well, she never brought the key. She must not have intended to do this. She didn't bring the money. No, she sat there and said to Whitty, she clearly, from her statements to Muhammad, is scared of being robbed because she thinks this is real. And she wants it done at the bank. She was giving him ideas. Mike's going to be going to the bank, pulling out $10,000. He has to give it to his business partner. Here's the bank on Glades and 441. He's going to be there at 8 a.m. right when it opens. You can do the hit and you can take the money. She wants her husband to finance his own murder. That shows all of her intent. She's thought this whole thing out. There's more evidence of her intent. On the mobile video, she's establishing her alibi. She's talking about, I can't leave town, that'll be obvious. I never leave town. Wipe my prints off those photographs. She keeps saying, I want to make sure this is solid. Questioning, is it going to happen immediately? When she's talking to Whitty, he says, I'll put 2 shots to the head. She's fine with that. He told you she didn't even flinch. She's giving him alternative ideas to make sure that this happens. And he kind of questions her, are you sure? She says, I'm 5,000% sure. I know you think I'm a pretty little girl, but I'm tougher than I look. Does that sound like the words of somebody who doesn't have the intent to make this happen? No. Read her body language on that video. There's not an ounce of hesitation. She's confident. She doesn't hesitate getting in that car. She doesn't hesitate talking to him. She bats her eyes to flirt with him. She knows exactly what she's doing. Reasonable doubt. State's burden of proof is beyond a reasonable doubt. Now, the judge instructed you, and you'll have those instructions to take back into the jury room. Reasonable doubt is not a speculative doubt. It's not an imaginary doubt. It's not a forced doubt, and it's not a possible doubt. What does that mean? You can't go back in that jury room and say, well, what if this, maybe that? Yes, you have to weigh the evidence, analyze it, discuss it. But if you find yourself back there saying speculative, that's not reasonable doubt. If you have an abiding conviction of guilt, you must find her guilty. Your job is to judge the facts of this case, Mr. Claypool told you to send a message to law
Objection,
enforcement
Judge. We
everywhere.
approach.
You may approach.
Mr. Claypool told you to send a message to law enforcement everywhere. That is incorrect. Your job is to judge the facts of Dalia Dippolito. Now, do you get to weigh law enforcement as witnesses? Of course, because they are witnesses. But I submit to you that what imperfections they had don't put flaws in this case. Is every investigation perfect? No. Does that mean there's instantly reasonable doubt? No. You cannot let sympathy or bias factor into your verdict. Your job isn't to think about what possible punishment might exist. Your job is to judge the facts. To go back there, take those jury instructions, go through each element, look at the evidence. Does the evidence meet those elements? And you'll find the answer is yes. You can't pardon her because you think the police were wrong.
Objection, Judge. Proper argument.
Overruled.
The police aren't on trial. This is the case of the state of Florida versus Dalia Dippolito. The judge told you in the instructions that you get to use your common sense. Common sense is one of those things that doesn't matter where you're from, where you grew up, what education you have. It's your street smarts. It's something that no one in this world can ever take away from you. And it's really important. It gets people through life. Use that common sense. Look at the evidence. Using that common sense. You were told yesterday that if you found her guilty, you would be playing into the evil of the police.
Objection and proper argument, Judge.
Overruled.
Do not let the defense bully you into a verdict.
Objection, Judge. We approach.
You may approach. Thank you. Again, law enforcement isn't on trial. You're to judge her. You must follow the law. The instructions say, your failure to follow the law would result in a miscarriage of justice. We picked you as jurors because you all promised us that you could follow that law. You raised your hand and you promised that. We're going to hold you to that. Go back and look at her statements. Listen to those videos again if you want to. Look at what she says. She tells Muhammad, you know, he divorced his ex-wife. They didn't have anything. If I filed for divorce, he's going to come after my ass. Killing someone? Come on. No one will be able to point a finger at me.
He snitched on someone. That guy's doing time. Do you know what killing someone is? Then she looks at Muhammad. After he says, come on, doll, you're planning someone to murder. She goes, smile. Ladies and gentlemen, remember her words. When she says she's going to do something, she's going to do it. And she did. She's guilty. Thank you.
All right, thank you, Ms. Laurie. All right, members of the jury, I have some final instructions to read to you. If you wish to follow along, it's under the subtitle Final Instructions. You'll find it on page 7 of the instructions I gave to you yesterday. In just a few moments, you'll be taken to the jury room by the court deputy. The first thing you should do is elect a foreperson who will preside over your deliberations, like a chairperson of a meeting. It is the foreperson's job to sign and date the verdict form when all of you agreed on a verdict in this case, and to bring the verdict back to the courtroom when you return. Your verdict finding the defendant either guilty or not guilty must be unanimous. The verdict must be the verdict of each juror as well as the jury as a whole. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during your deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I've given in this case, you must tell me by giving a note to the deputy. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the court deputy while you deliberate. If you need to communicate with me, send a note through the court deputy signed by the foreperson. If you have voted, do not discuss the actual vote in the note. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. Videos and recordings must be played back for you in open court. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in reaching your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Those are the written instructions I have for you. I do have one duty I have to discharge and a couple final instructions I have to give to you before I send you back into the jury room to begin your deliberations. Let me deal with my legal duty. Under clear Florida law, I can only send 6 of you back to deliberate. That means we have selected alternates for the case. It's my responsibility at this time to discharge the alternates. Mr. Jean and Ms. Van Dyne, you are our alternates. We're going to discharge you at this time with our thanks. We do have certificates of appreciation for you signed by the Chief Judge of the 15th Judicial Circuit, the Honorable Jeffrey Colbath. You can leave your notes on the chair. The deputy will immediately destroy them. No one's ever going to look at your notes. I know it's been a long trial, and often when I discharge alternates, it's difficult because you sit through the case and you don't get to deliberate. Let me tell you, your role in this case is key and is very important, because while I can only send 6 of you back, I must send 6 of you back. So if something happened to another juror without an alternate available, we would have to start this whole process over again. All of you sat through that process. You can understand how long that is. To go through the process of jury selection and also the trial. So it's an important function. We do appreciate your service. If you're curious about how your fellow jurors decide the case once the verdict has been reached, you can contact my office through my judicial assistant. We'll be happy to let you know how the case came out. So at this time, we're going to go ahead and discharge you with our thanks. The deputy's going to go ahead and take you out as usual back through the back. Okay, just a few. Counsel, you may be seated. Just a couple of final instructions, and I need to go over with you. There was some mention of these things in the instructions I read to you, but let me talk to you about how we're going to communicate with each other going forward. It's all going to start with a knock on the door. So if you have a question or if you've reached a verdict, what you do is you knock on the door. The deputy will come to the door and find out whether you have a verdict or a question. We will not be in the courtroom during the deliberations, so he'll have to summon everyone back into the courtroom. So it may take a few minutes to get everyone here. I don't require the attorneys to sit in the courtroom during deliberations, so it may take a little time to respond and get everyone back. So if you hear a knock on the, if you knock on the door, the deputy will come and find out why you're knocking. If we need to communicate with you, it's going to start the same way. The deputy will knock on the door. If you hear a knock on the door, please cease all deliberations and send someone to the door to find out why the deputy is knocking. Now, very shortly after we send you back in, within just a couple of minutes, you will hear a knock on the door. And the reason for that is we're going to gather up all the physical evidence that's been entered in the case, and we're going to take the original verdict form, we're going to put that together, and we're going to send it back to you in just a couple of minutes. So in just a couple of minutes, there will be a knock on the door. We'll send back the evidence, and we'll send back the verdict form. I mentioned in the written instructions with respect to any of the videos or recordings, there's no device back there for you to use, so if there's anything that you want replayed, you have to send us a note through the court deputy. We'll be happy to bring you back out and play anything you wish to have replayed. I mentioned in the written instructions you cannot take cell phones with you back into the jury room. You're going to be leaving them here. The deputy will collect them up. He may not leave them in the courtroom. He usually collects them up and keeps them separately. But rest assured, there'll be a deputy in the courtroom at all times during deliberations. We've never lost the cell phone of a juror. So rest assured, you will not lose yours. As we approach the lunch hour, it is possible that I may send Deputy Cascone back with menus so that we can buy you lunch so you can continue your deliberations if that's necessary. So at some point after you begin your deliberations, if you hear a knock on the door and we've already sent back the evidence, again, just send someone to the door to see why the deputy is knocking. With that said, you may take everything back with you except for cell phones and electronic devices. You're going to collect those up back there. He'll collect them up back there. We won't leave them in the courtroom. So he'll collect them up, and you can take everything else back with you into the jury room. All right, counsel may be seated. I'm going to need both sides to look at the evidence and then confirm for the record that the evidence is there and ready to go back. In other words, I don't want anything that was just marked for ID going back or anything being missed. So I need some from the state, some from defense to review the evidence. There's no point sending them back. They can't play them. I can send them back, but I've told them that they have to let us know. So you can send them back, but they're not going to be able to play them. The money can go back. Yeah, it can go back. Brian, those evidence tags have all been changed out, right? All right. All right, what's the objection? Well, if they want a particular tape view, they'll give us a description, what it is, and we'll find it. Can both, we done?
Yes.
Can both sides affirm for the record that the evidence is here and ready to go back? Somebody for the defense?
What, Judge?
I need you to affirm that the evidence has been reviewed and is ready to go back.
Yes, Your Honor.
Okay, state, Ms. Laurie.
Yes, Judge, I believe the only thing I did, I thought the plans had been the big plans of the cell phone records. Okay.
Mr. Williams?
Yes, Judge.
There's a question up here for you.
Did you put in the full thing of the phone records?
Did I put in what? The phone records are just the ones that
I thought it was just that there was the, yeah.
just the relevant ones, that's it.
Okay, so the evidence is ready to go back? All right. Neil, you might want to do the menus. You didn't? Okay, yeah, because it's 10 of 11. Right. So you get calls? It's better than you getting calls. It's amazing about cell phones is everyone keeps their own area code now. No one changes an area code. Yeah.
And we have one more housekeeping matter to address, Your Honor.
Wait till he sends that stuff back.
Sure.
Rian, this is the instructions as published. All right, Ms. Laura, are you handling this, or Mr. Williams? Go
At
ahead.
this time, Judge, we're renewing our motion to dismiss based on objective entrapment, arguing that the police's conduct or egregious misconduct rose to the level of objective entrapment. Namely, I'll just go through about 8 facts from trial. Mohammed Shihade initially approached the Boynton Beach Police Department because he wanted to get Dalia Dippolito help regarding domestic violence. And that was manufactured into a murder-for-hire plot. Boynton Beach Police Department tricked and or coerced Mohammed Shihade into agreeing to become a confidential informant despite him not understanding the agreement, not seeing every page of the agreement, not signing his name on the top of one of the pages. Boynton Beach Police Department threatened Mohammed Shihade with prosecution to ensure his cooperation with the investigation. Boynton Beach Police Department imposed a 72-hour deadline within which Mohammed Shihade had to secure Dalia Dippolito's participation in its sting operation. Boynton Beach Police Department forced Mohammed Shihade to wear a wire during the course of the investigation, despite him telling them he did not want to wear a wire, which we would indicate is a withdrawal of any previous consent. Boynton Beach Police Department planted surveillance cameras in Mohammed Shihade's car without his knowledge or consent. Regardless of which date this happened, this action still did take place based on his testimony. Boynton Beach Police Department intentionally destroyed or lost a recording of the conversation between Mohammed Shihade and Dalia Dippolito at the Chili's restaurant, or Boynton Beach Police Department refused to get a wire. Specifically, former Sergeant Paul Sheridan told former Sergeant Ramsey to F off, even when there was a couple hours to get a wire and it would be available. And in light of that, we lost any evidence of the Chili's meeting. And Boynton Beach Police Department forced Mohammed Shihade to wear a wire during the course of the investigation. Boynton Beach Police Department released videos during the course of the investigation that potentially compromised the future course of prosecution. And we would argue this in light of Your Honor's previous ruling that this is an issue solely of law, not of fact for the jury. We maintain our position that this is an issue of fact for the jury.
Okay. I'm not even sure procedurally you can renew at this time, but I'm going to assume you can, because it's really a pretrial motion to dismiss, which I've already ruled upon. My review on the totality of the evidence has not changed. The motion to dismiss is denied.
Thank you, Judge.
All right. Okay. Everyone's given their cell phone numbers. Is that right, to Neil? Yes. Okay. So we'll be in recess until we have a question or a verdict.
Okay, folks.